Hello, my name is Ian Larkins of Radius Law and welcome to our special edition commercial bulletin brought to you in association with LexisNexis. It's the start of a new year, so time to look ahead at the key legal changes expected in 2019. The UK is currently scheduled to leave the EU on the 29th of March 2019. There are broadly three options: a cliff-edge no deal and transition to the WTO rules, remaining in the EU, or transitional arrangements which are proposed to end on the 31st of December 2020. Until a decision is made, it's difficult to make plans. However, we do recommend some contingency work, particularly for those businesses that rely on European workers. European workers currently living in the UK will be able to apply for settled status in 2019, allowing them to remain indefinitely in the UK. We'll of course keep you updated with practical guidance as the Brexit news develops. New annual corporate governance reporting requirements will apply to financial years starting since the 1st of January. The reporting requirements vary depending on the size of your company. Most large companies will need to show how the directors have had regard to the environment, stakeholders and other considerations required by the Companies Act. Very large companies will need to report on the corporate code that they have adopted and how it has been applied. Quoted companies with more than 250 employees will have to make certain reports concerning the CEO's pay and the effect of a share price on executive pay. The European Commission had planned to replace the existing Privacy and Electronic Communications Regulations (PECA) in May of last year when the General Data Protection Regulation was introduced, but this was postponed. We do not yet have any implementation date, but anticipate that it will be in the second half of 2019. The proposed regulation has some worrying changes. The soft opt-in that allows marketers to use electronic marketing to existing customers will be time limited to 12 months. Websites will need to have functionality to facilitate individual and specific consent. All live marketing calls and B2B marketing will need prior consent. Now, the implementation of the e-privacy regulation in the UK is currently subject to some intense lobbying, and the regulation does allow some member states to deviate from some provisions, including the need for consent for live calls, and could of course be avoided by a hard Brexit, so it's not a done deal yet. The gig economy has been hot in the news for the past 2 years, and we expect to have the Court of Appeal decision in the Aslam v Uber case early in 2019. This case will rule on whether Uber drivers are self-employed contractors or whether they are workers and therefore entitled to minimum wage, whistleblowing protection and holiday pay. There are similar cases in the pipeline, and we anticipate the Uber case will be appealed to the Supreme Court, whatever the outcome. So this story is likely to rumble on throughout the year. We also expect to hear the final determination of the Court of Appeal King v Sash Window case. Now, in this case, it's already been decided that King was wrongly classified as self-employed rather than being a worker. The outstanding question is how much holiday back pay he should be paid. The expectation is that the Court of Appeal will rule that he's entitled to holiday pay for all of the time he was a worker, 13 years. The Taylor Review in 2017 also focused on the gig economy and made many recommendations. One recommendation was to ensure that every worker, rather than only employees, has the right to an itemised pay statement. Now, following an amendment to the Employment Rights Act of 1996, this change will be law from the 6th of April. There were some important cases on equal pay in 2018 involving the big supermarkets. These cases concern store staff who are mainly female, who claim that they should be paid the same as distribution centre workers who are mainly male. Asda's case is the most advanced and was heard by the Court of Appeal in October. This is an appeal from the Employment Appeal Tribunal decision in 2017 that decided that there was equal value between the two groups of staff and that their pay should be comparable. We expect to hear the outcome of this early in the year, but suspect that there will be further appeals. Last year's Employment Appeal Tribunal decisions in Ali v Capita Customer Management and Hextall v Chief Constable of Leicestershire Police both related to shared parental leave and whether it is sex discrimination to deny male employees the chance to receive enhanced pay whilst taking shared parental leave, equivalent to the enhanced maternity pay that will be available to female colleagues. The EAT decisions had some inconsistencies and both are being appealed to the Court of Appeal. It's expected that these hearings will take place separately in May. Private organisations with 250 or more employees will again be required to publish their gender pay gap figures on the 4th of April. Although this is the second time that employers will be reporting, we anticipate that they will be heavily scrutinised to identify what efforts have been made to address any significant pay disparity highlighted in the 2018 figures. There will be the usual rises to minimum wage rates in April, and the minimum contributions for auto-enrolment pension schemes will increase for both employers from 2% to 3% and employees from 3% to 5%. The government's 2017 Modernising Consumer Markets consultation sets out 3 principles to improve consumer markets. Competition should be central to the UK's approach. Consumers should benefit from new technology and new business models with competition and regulation working for consumers. And consumers should be able to obtain redress when things go wrong. Some of the proposed regulatory changes include that all consumers should get a good deal, not just those who shop around. Improved transparency in the way that pricing and other personalisation works. Terms and conditions to be shorter and simpler, as reports have shown that fewer than 1% of shoppers open the terms and conditions. There should be removing of subscription traps and more power to law enforcers to allow them to ask the courts to impose fines as a standalone remedy, with a proposed financial penalty of up to 10% of a firm's worldwide turnover. Now, there's not yet a timeline on these plans, although we are already seeing action in some areas. In September last year, the Citizens Advice Bureau launched a super complaint to the Competition and Markets Authority over its concerns that loyal customers who stay with their providers, often on default or rollover contracts, can end up paying significantly higher rates for new customers enticed with more favourable offers and rewards. In addition, the EU has announced its planned package of reforms to deliver a new deal for consumers. These include GDPR level of fines for breaches that cause mass harm, making it easier for consumer bodies such as Which to bring group actions to seek redress on behalf of consumers that have been harmed by an illegal commercial practice. New rights for consumers to seek compensation when they have been affected by unfair commercial practices such as aggressive or misleading marketing. More transparency for the sales on online marketplaces. Subject to Brexit, we expect for proposals to be law by May 2019, but there will be a 2-year transition period. Since the 3rd of December, new laws have prohibited traders selling goods or services, subject to certain exceptions, in the EU from unjustified discrimination on the grounds of nationality, place of residence or place of establishment in the EU. The classic form of discrimination that the law aims to stamp out are websites that automatically reroute a user to a website that's aimed at the country where that user is resident. As this law has now been implemented, it's important to review the operation of websites and terms and conditions to ensure there is no unjustified discrimination. Thank you for tuning in for this month's commercial bulletin. For more information on any of these stories, please contact me or any of my colleagues at Radius Law. We'll take a short break next month as we are reviewing the format of these briefings. If you are not already signed up to receive our bulletins, please sign up now to ensure we can keep you updated. This can be done on our website.